You've been appointed personal representative of a deceased estate, and now it's time to give notice to the interested parties. Hi, I'm Darren Findling of the Probate Pro, and I'm going to walk you through a particular notice requirement under Michigan law called the Notice of Appointment and Duties of Personal Representative. As you can see from the slide here, it is PC 573, and PC is a probate court form under the State Court Administrator Office, SCAO. So if you're looking for this on Google, it's SCAO space PC 573. One of the nice things about all of the Michigan-related forms is that the information about where that form arrives from, meaning the statutes and court rules, are specified at the bottom corner of the form. In this particular case, there's a statute, MCL 700.3705, and a court rule, MCR 5.305, that provide instruction to the personal representative as it relates to their duties and what requirements they have in terms of noticing to the interested parties that they've been appointed personal representative and they're providing notice of that appointment. Let's walk our way through this. First, it's important to also understand that that little space at the bottom where it says attention is worth reading because, of course, the form itself does not fully state all of the legal requirements of a personal representative. These are just some of the statutory ones that you're required to provide notice at the onset. So don't just assume that if you sent this notice, your responsibilities as personal representative are concluded. They're just beginning. So the statute, which is MCL 700.3705, speaks to providing certain notices of your appointment of personal representative within 28 days or in a time frame set forth by court rule. And in fact, the court rule MCR 5.305 shortens that time to 14 days. So you have 14 days to send notice to all the interested parties of your appointment of personal representative. When you do so, you're going to complete this particular SCAO form, SCAO form, by putting the county, the file number, and the name of the deceased estate. From there, you're going to give notice to the interested persons. Now that term, interested persons, doesn't necessarily mean an individual. It could be, for example, an entity or a charity or the Attorney General's office. The term persons under Michigan law can be quite broad. To understand who you have to give notice to, you really have to understand the EPIC, the Estates and Protected Individual Code, that relates specifically to your estate. So I can't, in this particular explanation, tell you in your file who you should be providing notice to. But please make sure you're familiar with the statute or court rule and consult with your attorney. From there, you're going to identify the date of your appointment and whether you're serving with or without a surety bond. A surety bond is a guarantee of your performance as personal representative. It also identifies where those filings occurred within which court, and a very important consideration, whether that probate administration will be supervised or unsupervised. Now, in a supervised administration, there's an enhanced filing requirement and supervision requirement that exists throughout the pendency of that particular estate. So it's really important to understand what it means when a probate estate is supervised versus unsupervised. If you are receiving notice and it's an unsupervised administration and you're concerned about the performance of the personal representative, it's really important that you consider changing it from an unsupervised administration to supervised to provide more accountability, more court oversight. It may increase the expense, but you'll be provided with more oversight as to the steps rather than the administration occurring without much court involvement. It's a consideration you should really, again, consult with your probate attorney to understand what the best step is, supervised or unsupervised. Here, you're going to identify whether there's a will and provide whether it was admitted to probate and whether you're providing a copy of that will or the relevant provisions of the estate plan. Also, you're going to indicate here about the lack of supervision under certain particular circumstances and the informal appointment of the personal representative and your right to object to these and how you object to either the appointment of personal representative or for the admission of the will or other related affairs of the personal representative. Under number 5, it speaks of your right to petition for the court at any time during the administration. So even in an informal, unsupervised administration, there's a case number, there's a court, a probate court, that has jurisdiction over that file. So when a dispute arises as to the performance or the actions of that personal representative, you have a forum, that forum being the probate court, to resolve those disputes. Also, if there were questions about the interpretation of the will or issues that need instruction from the court would oversee those particular responsibilities. And this particular notice tells you that you have the right to petition at any time, and it's done by filing something with the probate court with the applicable filing fee. The next section talks about what it means to be an interested party, whether you're an heir in an estate that has no will, or a devizee, which means you're identified within the will, and what rights you have to understand the attorney fees that are being charged in relation to the administration. Item 7 speaks about that the estate taxes need to be paid, and that you have a responsibility not just to the taxes, but inclusive of taxes as it relates to all creditors of the estate. In addition, that the estate will remain open for 5 months minimally in an unsupervised administration, but that at the end of a calendar year, there's a requirement to keep and provide notice to the court if you're going to continue the estate beyond that year. The lower section's pretty intuitive. The attorney provides their information, the personal representative provides their information, and the date of notice is reflected there. And again, the court rule says within not later than 14 days after the appointment, this is a required notice that is served. At the Probate Pro, we're passionate about everything probate. If you have questions about this particular form or any probate-related issues, visit us at theprobatepro.com or call us at 833-PROBATE.